Good day, Crime Talk aficionados. This is Scott Reisch for Crime Talk, and thanks for tuning in. First on the docket, what could the court have sealed in the Lori Vallow case? I think I know what it was. Second, a 13-year-old boy to be tried as an adult after shooting his brother. Third, the body of Naya Rivera has been found. Fourth, the St. Louis attorneys who were seen defending their property have had a firearm seized from their house. Fifth, another George Floyd-like video. Sixth, a former U.S. gymnastic coach arrested. Seventh, a priest who stole from his parishioners to support his secret lifestyle is now deceased. And finally, our dumb criminal contestant of the day. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch from Crime Talk, and thanks for watching. As always, if you haven't already done so, we'd ask that you please hit that subscribe button, hit that like button, and leave us a comment. Hit that little bell so that you receive future notifications of when we go live or put up new content. We are back in the office today. Last week, we were on a road trip, a little adventure, but hopefully here in the Crime Talk studios, you won't have to worry about audio difficulties or the wind, apparently, that I was trying to bring from you from the gorgeous Rocky Mountains. A lot of people complained about that, but hopefully we can do just fine here. First on the docket, what could that possibly be that the court has said to file under seal in the Lori Vallow case? I think I know what it is. As you may recall, at the bond reduction hearing for Lori Vallow in the original case that started out regarding the abandonment of children, which has since been reduced down to misdemeanor charges, Ms. Vallow's attorney, Mr. Means, stated on the record that one of the reasons why Ms. Vallow wasn't a risk was because her husband, Chad Daybell, resides in the area, and he can say he's a good guy basically because he stated on the record he represented him. Fast forward several months, and at the advisement for the new case where Lori Vallow was charged with a conspiracy with Chad Daybell for delaying the hindrance or basically delaying the discovery of the human remains of her two children, Mr. Means was asked point blank by the court on the record whether he had or continues to represent any co-defendants in this particular case. And Mr. Means responded with a "No, I have not." The district attorney immediately chimed in and said, "Oh, yes, he has." And I was watching that live, and I thought my jaw was going to drop because I thought of two things. One, has a material misrepresentation been made to the court? And two, a conflict exists because we all heard what Mr. Means said in regards to representing Chad Daybell.
The amount of resources that can be saved in order to allow that to happen, and given that I represent her husband, Chad Daybell, in the event that there's an issue there.
Mr. Means, have you ever represented any of the alleged co-conspirators that are set forth in the criminal complaint?
No, Your Honor, other than Mrs. Daybell.
And we talked about it. We did a show about a conflict of interest. And an attorney cannot represent two people where you have competing, conflicting interests. You just simply can't do it. It is unethical. And you can't talk to one client and then talk to another potential client and then say, well, I'm not going to represent you, even though the client came to that attorney seeking legal advice. An attorney-client relationship has been formed, even if he was not retained or paid for. All right. So the attorney cannot go back to his original client saying, well, I'm not going to represent that one, even though he told me things about the case, which could be used to original client's advantage. The attorney would have to get off of both those cases. You cannot do it. When you have attorney-client confidences that can be used against another person, particularly in a criminal co-defendant case, it's done. All right. So Friday afternoon, the court granted a motion, and it was an order to seal. And it's in the Lori Vallow, a.k.a. Lori Noreen Daybell case. It's the CR 2022-20-0838 case. And the first paragraph is stating that the rule as to why things should be sealed by the court and that public shouldn't have access to it in any way. And the final paragraph is the one that is of significance. It says the court finds that the defendant's privacy interests and rights to a fair trial outweighs the public interest of disclosure in the matter of whether an attorney conflict exists. So, what does that mean? It means that, just like the court asked for, the district attorney filed a motion probably to disqualify Mr. Means as the attorney for Lori Vallow as well as for Chad Daybell, even though he has retained his own new counsel. But the district attorney's position, I would gather, would be that Mr. Means needs to withdraw. I'm sure Mr. Means was trying to do some tap dancing in his motion, trying to say whether there was or was not an attorney-client relationship, because he stated to the court, and as an officer of the court, you have a duty of candor to the court at all times. You can't just throw things out there. I know a lot of people say, oh, you're a defense attorney, you're lying. Yeah, no. You can't lie to the court. You can't make material misrepresentations to the court. If you misspeak and you say, oh, I thought it was on a Thursday and it was a Friday, that's not going to get you in trouble. But when the court asks you point blank, have you represented somebody, and it's completely inconsistent with what's been on the record, somebody's got some trouble coming their way. Mr. Means should say there's a conflict, I'm out of here, refund any money to Lori Vallow that he has not earned and let her get a new attorney. I don't see this as a waivable conflict, and even if Mr. Means says that it is a waivable conflict and Lori Vallow were to consent to that, I don't think it is permissible, and the judge should say that it's unethical and not allow it. We'll see. What do you think? Should Vallow cut ties with Mr. Means now or ride it out? Maybe it creates appellate issues down the road. Let me know what you think. Second on the docket, a 13-year-old boy in Pennsylvania will be tried as an adult for fatally shooting his 9-year-old brother in the head, according to online court records. Braden Leroy Wright of Waynesboro was charged Wednesday with first-degree murder, criminal homicide, and second-degree aggravated assault. He remains in custody as his request for bail was denied. According to police reports, the brothers were playing cops and robbers at about 6 a.m. on Wednesday morning. The 13-year-old told arresting officers that he retrieved one of the two loaded 9mm handguns that the father kept in the living room couch to use during the game. The boy's father, Mark Schneider, later told the police that he kept the guns loaded and unsecured for home protection. According to the police report, Braden told the officers that he had become angry with his brother because he was not complying with his commands in the game. Braden then reportedly put the muzzle of the gun to the back of his sibling's head as he lay on the couch watching YouTube videos. Braden also told the police that he was aware that the gun was loaded and that he pointed the gun at his brother's head and pulled the trigger. Needless to say, the 9-year-old is now deceased, and the family is seeking a GoFundMe page. And on that GoFundMe page, the people state, we not only lost our 9-year-old precious little boy, but we could potentially lose his 13-year-old brother. Well, this is a tragic case for sure. And obviously a 13-year-old in most jurisdictions, that's right on the cusp of being able to be tried as an adult. Although a 13-year-old going to an adult prison is not something that any 13-year-old would want to partake in. And it would be a very difficult decision for anyone that knows what the prison system is like to actually want to send a 13-year-old to prison, specifically to an adult prison. Clearly, young Braden confessed to murdering his brother. He knew that the gun was loaded. He was aware of his conduct, practically certain to cause the specific result. It is a murder case. The age is somewhat mitigating. What one would have to consider if they were a prosecutor in this case is whether the father should be charged for basically allowing the firearm to be kept in a place, i.e. under the seat cushion in the couch for home protection, whether that's some sort of negligence which could result in criminal charges. And you will hear no one be the proponent for the Second Amendment more than me, but you have to use common sense and good judgment. You can have firearms stashed throughout the home, but you don't want the children to know where they may be, so these types of things simply do not take place. Tragedy all around. Next on the docket, the body of Naya Rivera has been found. Earlier today, reports came out that they had found a body in the lake where Miss Rivera was in fact missing. It seemed rather likely that it was in fact her body, and the police have since confirmed that report. For those who do not know, Miss Naya was the missing Glee actress, and she went missing on July 8th after going on a boat ride in the lake with her 4-year-old son. She disappeared while swimming in the reservoir northeast of Los Angeles. Her son was found asleep on a pontoon boat that had been rented some 3 hours earlier. According to police, the 4-year-old stated that his mother never got back in the boat after swimming. Although the authorities are saying there's nothing to indicate that this was foul play and nothing more than an accident, it is worth noting that Miss Rivera is now the 3rd cast member from Glee who has passed away. Corey Monteith passed away as a result of a drug overdose. Mark Salling committed suicide, and now Naya Rivera by accidental drowning. Let me know what you think. Something nefarious or just tragic accidents that take place during life? Do you remember the 2 personal injury attorneys from St. Louis who made news for protecting their home with a small pistol as well as an AR-15? Well, guess what? The district attorney there had stated that they were going to open an investigation into this particular case. Frankly, other than perhaps some very poor gun safety, it appeared to me that the McCluskeys had not committed any crime. According to all of their statements that were made, is that they were afraid for their lives, the lives of their animal, as well as their home, as people had threatened to kill them, as well as to burn down their residence. You can defend yourself. You can defend your property. The McCluskeys never fired the weapon at anybody. And according to reports now, Mr. McCluskey never had his finger on the trigger as well, and the safety never came off. Patricia McCluskey's firearm apparently was never operable. It didn't work. Guess what? You can't have a crime of doing something with a firearm if it is not a functioning firearm. It's just a piece of metal. So I get it that people want some sort of justice here, but I don't see that the McCluskeys did anything wrong in this particular case. Additionally, the district attorney would have to come up with somebody to say that they were threatened or that the firearm was actually pointed at them in a menacing way. I'm sure they could probably look and find somebody if they were really looking hard, but this seems more like a case that maybe the district attorney and the police may want to be a little more interested in tracking down who broke the gate into this private neighborhood when they were marching their way to the mayor's office than people concerned about their home being destroyed, and they took up arms to do so. And we have said it before, and we will say it again. We are all about the First Amendment. We are all about peaceful protests. But when you start breaking other people's things and damaging other people's things or harming other individuals, you are no longer peacefully protesting. You have now become a potential criminal. Next on the docket, another George Floyd type video has surfaced. You know, it's been said that a smart man learns from his mistake, a wise man learns from the mistakes of others. Well, apparently an Allentown police department announced that one of their officers is neither wise nor very smart. They've opened an investigation into an incident by the Lehigh County District Attorney's Office, and the department's also conducting an internal investigation over the use of force. The Allentown Police Department said they'll begin their investigation, which will include the reviewing of a video posted on social media, witness statements, and additional videos of the interaction. Apparently, Allentown PD says they began when An Allentown PD officer observed a male outside of a hospital who was vomiting and staggering on the street. They say the erratic behavior resulted in officers and hospital staff interacting with this particular individual, who began to yell, scream, and spit at the officers and hospital staff. Now, in most jurisdictions, spitting on a police officer is still an offense. Spitting on a hospital worker is an offense. Spitting on another individual is an offense. In most jurisdictions, it's a felony. The police say that the officers attempted to restrain the individual, and all parties ultimately wound up going to the ground. They say that the individual continued to be non-compliant, and which time it required the officers to restrain the individual. The man was ultimately escorted to the hospital for treatment and ultimately released. And the reason why I say that these police officers are neither wise nor smart is that, one, you would think they would have learned something from the George Floyd matter, which is don't put your knee in somebody's neck. And second of all, these officers may just be stupid because their police department recently banned the use of chokeholds and other neck restraints, so that at the very least they would seem to violate policy in this particular case. So the video, as you can see, speaks for itself. The question has become whether it's justified. At a minimum, this officer should not have done this. And let's face it, ladies and gentlemen, the police need to do better and cleaner than everybody else. And they can get assistance literally immediately if they cannot handle the particular situation. But if anyone's ever dealt with people in conflict type situations, for example, if you've ever hired security or bouncers, yeah, you'd like to have a big guy, but guess what? You don't need a guy that wants to go around beating people up. You want to hire people that can defuse and talk down a situation. I just don't understand why this is such a difficult concept in the world of police that we have today. Don't we all remember hearing stories about police officers that went their entire career and never had to pull their firearm? It seems like people were able to talk and diffuse the situation much more, whereas now it seems like the police officers want to throw people to the ground and tase them much quicker. Let's start hiring police officers that can diffuse the situation versus throwing fire on it. All right, a quick recess. Ladies and gentlemen, go to CrimeTalkSearch.com. Sign up for a subscription for a background investigation. It's simple. You will be happy that you did. You can have a no-risk trial. This search that you do covers millions and millions of public records, and it spits it out into a single report. And it's going to include social media. It's going to include phone numbers, email addresses, criminal records, bankruptcies, civil court records, including divorce and marriage records. Ladies and gentlemen, if there's ever a time you want to make sure you know who you're dealing with, it's today. How are you going to do it? Are you going to take somebody's word for it? No. Trust, but verify. That's why you need to go to CrimeTalkSearch.com, sign up for your background search subscription. You'll be absolutely satisfied and happy that you did. Next on the docket, a former USA Gymnastics coach has been arrested on 14 charges of lewdness with a minor. That's right. Terry Gray, a former USA Gymnastics coach, has been arrested on multiple charges of lewdness with a minor. According to the Las Vegas Metropolitan Police Department, sex crimes detectives arrested Gray, who's 52, on 14 counts of lewdness with a child under 14. Gray was a gymnastics coach in Las Vegas from 2009 to 2015. He had also coached in Ohio and California, and though the charges only apply to incidents in Nevada, the police believe that the alleged crimes began in 2007 and through 2013. Gray was suspended in October by USA Gymnastics, which is the national governing body for the sport. His 2-year suspension was put in place after physical and sexual misconduct allegations as the investigation was launched. Gray will appear in court and be advised of the charges. He's currently being held with no bond. Now, quick side note. If you want to see a good documentary about how these pedophiles get into a position where they can sexually assault young women, go and watch Athlete A. This is the documentary about Dr. Nasser, who worked for not only the university in Michigan, he was also the lead doctor/trainer for USA Gymnastics. The documentary shows one woman and one parent who had the courage to go forward, and it opened up a floodgate of complaints against Dr. Nasser, who apparently, when they searched his house and he had just thrown out his trash of 3 computer hard drives that contained some 35,000 inappropriate images of young children, it also showed that he liked being around young women. And what's the best way to do that? You go where the young women are, okay? I've said it before and I've said it again. These men may be great gymnasts, but are there no female gymnastic coaches that can be around the females? Why would an organization want to create a situation where something like that takes place? And I'm sure in this particular case, and although Terry Gray is given the presumption of innocence, there is going to be more incidents, and there's going to be more cases where it was just incidental rubbing, incidental touching. Ladies and gentlemen, think about it. Where do you find these gentlemen oftentimes that have been charged with these cases? Where the children are. Coincidence? No, it's not. It's by design. Okay? Take it from a criminal defense attorney. Use your common sense. And go to CrimeTalkSearch.com and do a background search on everyone that gives you anything other than a warm, fuzzy feeling. Okay? When your spidey senses start tingling, that's when you need a criminal background search. And Coach Terry Gray, I think he's got a lot more trouble coming their way. And also USA Olympics, as I mentioned in the documentary, it's a great story of how the organization ignored and covered for Dr. Nasser in that particular situation because he was a great guy and he was just volunteering his time and doing all sorts of weird exams on these young girls that were not to be done, but nobody wanted to bring it forward because it would look bad for the organization. If you know about it, it's a huge problem. Next on the docket, do you remember the case of the Oklahoma father that had his 2 children die in his truck? Well, we brought you this story originally because Dustin Lee Dennis, who's 31, was formally charged Friday afternoon with the death of his 2 children who were found in a hot car. As you may recall, Mr. Dennis was originally charged in June for the death of his 2 children. He claimed that he had gone to a quick convenience store run with the kids, went inside, he took a nap, the children went outside to the vehicle and must have passed away while he was asleep. Video footage from a neighborhood security camera actually confirmed that particular situation. Once the video was discovered, Mr. Dennis was given a PR bond, and it seemed likely the charges were going to be dismissed. Now Mr. Dennis faces 2 counts of second-degree murder. I'm unsure what the factual basis would be in this particular case, given perhaps maybe extreme indifference for a second-degree murder charge. However, it would seem if one were going to charge Mr. Dennis that there would be some sort of negligent homicide or some sort of child abuse charge relating to negligence. And then you have the option of, should Mr. Dennis even be charged? Now, certainly being a parent is exhausting and you can be tired, but you usually don't go to sleep when your children are out and about. Is it going to happen? Yes. And we've all probably done it if you've had children, and thank God nothing bad happened. But if they did, but do you think that it would be worth sending someone to prison for? Do you think that Mr. Dennis isn't going to beat himself up worse than any punishment the courts could possibly impose for the rest of his life? I have mixed feelings about this, ladies and gentlemen. Certainly, he was negligent. His children passed away. It was preventable for sure. But the question is it worth sending someone to prison for a lengthy period of time? Let me know in the comments what you think. Sometimes tragedies are tragedies. I've seen cases like this where no charges are filed because, frankly, the district attorney looked at it and said, there's no more that we can do that's going to change this conduct or deter this type of conduct from occurring from this particular individual, and they're in absolute deep remorse because of it. Be curious to see as the facts develop further in this particular case. Next on the docket, if you've ever watched the 12 Undeniable Truths, according to a criminal defense attorney, which we have a link to hopefully here in the video, one of the undeniable truths is that everybody has a secret. A lot of people live secret lives, have double lives that take place and nobody knows. Well, the next story on the docket is exactly that. A priest, a former priest now by the name of Peter McCluskey, resigned as the pastor of the St. Francis de Chantal parish in the Bronx after parishioners brought a lawsuit in 2015 saying that he had stolen at least $1 million from the parishioners by dipping his hands into the parishioners' gifts to the church. And what the former priest was doing was that he was using it to pay his bodybuilder sex master. Now, $1 million for a priest who is taking the vow of poverty, you could only imagine what he could be doing with that. Perhaps he's helping the poor, or he could be spending it on illicit prescription drugs. He could be buying a house for his gay lover. Those are all things that was alleged that Mr. McCluskey had done with the $1 million. The Archdiocese conducted their own investigation and determined that funds were in fact stolen, but it was only about $22,000, and the Archdiocese reimbursed the funds. No criminal charges were ever filed against the priest, but the lawsuit is now over, given the fact that Mr. McCluskey has now passed away. Ladies and gentlemen, your Catholic priest stealing money to support his gay lifestyle. You just can't make this stuff up. Next on the docket, our dumb criminal contestant of the day. Our dumb criminal contestant involves, you bet it, you betcha, that's right, another mask case. And this lucky contestant today is Treg Palmore. He's 49, and he apparently went into a Marathon gas station and was asked to put on his mask or leave the store. Mr. Palmore refused, and when the clerk came around the counter and asked Mr. Palmore to leave, he assaulted the clerk. Felony charges were filed against Mr. Palmore, and he has a lengthy criminal record for armed robbery, burglary, cocaine possession, battery, trespassing, theft, stalking, and a sundry of probation violations, clearly showing that past performance is indicative of future results. So, for Mr. Palmore's inability to let things go, or to simply leave the store, or put on a mask, or maybe pull his shirt up around his face so he can complete his purchase, no, he decided to assault an innocent clerk, and it was captured on videotape. Mr. Palmore, you are our dumb criminal contestant of the day. Congratulations. Now for the winner of the dumb criminal contestant of the week, it was the individual known as Haffy. That's right, the man with half a brain who lost it in a car accident because he was drunk and decided now to set his mattress on fire, endangering all in the apartment complex. Haffy, congratulations. You'll always be a winner in our book. Contact me at scott@scottreisch.com, and we will send you a Crime Talk mug at no cost to you. Now, if you would like a Crime Talk mug without trying to become a dumb criminal contestant of the day, all you have to do, hit the link to Teespring, and there's some really cool new designs up. Take a look. I think you'll like it. You'll want a mug. That's all we have today. Quick reminder, tomorrow we will do our Tuesday night live on YouTube as well as Facebook. And immediately after that, we will go to our private conversation with our Patreon members. So if you have not signed up to be a Patreon member, please do so. Send your questions, all Patreons, and we will answer them. We will stay as long as we have to answer all of your questions. That's all we've got for Crime Talk today. It's good to be back in the Crime Talk studios. Have a great day. We'll talk to you later on Crime Talk.